My Lords.
Yes.
Ground 2.
Yes.
My attempt to rely on selectivity directly to argue that there was no breach of the state aid rules as a ground for summary judgment was rejected by the learned judge for my failure to comply with the notice requirements, 14-day notice requirements, under CPR Rule 24.43b. We didn't appeal that. It does not mean that selectivity is therefore not a permissible argument of law as to the excusability of an assumed breach. And that's how the argument proceeded. That is an argument of law that's classically for a skeleton argument. And I do just ask the court to bear in mind that I didn't have a pleading from a learned friend on sufficiently serious breach until little more than a week before the hearing. So we were, as I've already mentioned, playing catch-up at some point, to some degree.
Well, I understand that, but we're stuck with what the judge found, which was that the raising of this point, at least insofar as it goes to breach, was, I think he uses the word substantially unfair.
Yes, because of the failure to give 14 days notice
Yes.
as a ground for essentially advancing it in a defence and a notice of application. But he wasn't saying that it was unfair to rely upon it in relation to argument as to excusability of assumed breach.
Where does the judge address that fine distinction?
Well, he must have had it in mind because he had regard to selectivity.
The substantial unfairness is it's not simply a theoretical point. The finding is substantial unfairness. In other words, they didn't have time to deal with it, to prepare to deal with it. Now, of course, there are a lot of arguments about whose fault that was. But as I say, we are where we are. The judge said substantially unfair. And I'll be frank, the difficulty I have at the moment is if it was substantially unfair to deal with that argument, it was substantially unfair to deal with that argument in whatever guise.
I think that the point the learned judge was making is it was substantially unfair to deal with it as a self-standing ground for striking out. If I had not attempted to strike out on that ground and had just relied upon selectivity, as indeed I did, as to going to excusability of breach, then the first point at which my learned friend would have been put on notice of that would have been on exchange of skeleton arguments. Because that wouldn't have required a notice of application. It wouldn't have required pleading and defence. It's a classic argument of law for skeleton arguments.
Is that right? Seriousness, yes, and selectivity are legal concepts, but they're dependent on the fact how they're applied depends on the factual context. And wouldn't you expect in your pleading to say, yes, there was a breach, or if there was a breach which is denied, it wasn't very serious because we genuinely relied on our view of the law, which we reasonably held, albeit you might hold it's wrong, something like that?
In the pleadings, because my learned friend didn't plead sufficiently serious, anything going to sufficiently serious breach, our defence was, you haven't pleaded sufficiently serious breach. As a matter of law, that doesn't give rise to liability and damages.
Yeah, therefore your case was you haven't pleaded it properly, so this aspect of your claim should be struck out.
Yeah.
And that's all. That's as far as it ever got. So there was never actually a pleaded case on seriousness on either side.
On seriousness, my learned friend pleaded it by way of reply.
Yes.
A little more than a week before the hearing, and then recognising that's not good enough. The week of the hearing, sought application to amend their particulars of claim to plead sufficiently serious breach. So that's why I say we were all playing catch up.
Well, that's why I say, if I'd been the judge, I'd have said, well, it's all or nothing. You've got 15 minutes. Either it all goes in and we don't have this artificiality, or it's adjourned.
Well, my lord, the way the judge dealt with it, I think, was fair to my learned friend, because normally, had this been just raised by way of legal argument, that would have been for the skeleton arguments.
No, it's not a question of legal argument. You're saying these two things are not we're not comparable with TDC. That's the argument. I'm bound to say I'd have expected that sometime before the skeleton argument. Now, I take the point. You say, well, he hadn't pleaded sufficiently serious. So there it is. That's why I go back to it's either all in or nothing's in, and it gets adjourned.
My lord, the way in which the learned judge did deal with it, in my submission, was fair to my learned friend and did give them a proper opportunity to address submissions to the judge on the relevance of selectivity.
But he says not, and he has a passage in his skeleton argument sets out what evidence he would have called if he'd been allowed to deal with that.
Well, I mean, it is the characterisation of whether an error, an assumed breach, is nevertheless an excusable error or not, is a matter for legal submission. And this was submission on authority based upon the judgment of Mr. Justice Warren in the VAT Judicial Review.
Yes.
And
well,
so
I appreciate that the decision of Mr. Justice Warren is potentially key to that aspect of the judgment. But anyway, that's your submission on that. I think my lord had another. Did I interrupt?
No.
No.
Thank you.
Sorry.
Thank you.
All right.
Am I right in understanding what you rely upon is that the ground upon which you were not allowed to argue for strikeout was Practice Direction 24 Para 2.3, requiring the point to be raised in advance if it's to be relied upon as founding a summary judgment application?
correct.
You say that simply doesn't apply to this argument.
Yes, because we're addressing submissions to the judge on the excusability of an error on the basis of an assumed breach. And that's a matter for legal submission on authority. And that takes us then into Negassi. And on my learned friend's case today, Hodge Chief, which I do want to address your lordships on.
So, excusability is a matter of legal submission.
Yes.
You can't have any evidence either way on excusability. Point 5 of Negassi. I thought point 5 cried out for evidence. I'll just find it.
My lord, where we're dealing with an assumed breach, either there was an obligation to notify.
Whether the infringer was acting intentionally or involuntarily.
Yeah, I'll deal with that
Or
point.
whether there was a deliberate intention to infringe as opposed to an inadvertent breach. It's not law.
It's a matter of mixed fact and law, but when you're dealing with an assumed breach, then the position is that the appellant says there was a legal obligation on the council through the UK to notify to the European Commission before proceeding to discharge its obligations under the Environment Protection Act. And the council, in its pleading, says we are discharging our duties under the Environment Protection Act. Now, you don't need more than that to deal with the legal characterisation of what's taken place. The correspondence referred to in the pleadings makes it plain that the council never considered notification, because the council is carrying out its obligations under the Environment Protection Act. You don't need more evidence than what's pleaded, and not really an issue.
Right. So if that's wrong, that's your submission, and it'd be for us to say yay or nay to that. But if that's wrong, then we have the problem that the judge said that this issue was unfair. If you're wrong, that in fact it's a matter, effectively it's a matter of law, and from the pleadings nothing else was necessary.
It's unfair to rely upon it directly as a ground for seeking summary judgment, but he wasn't addressing the question is this unfair as a factor to take into account the arguability as to whether this is selective or not in an assessment of whether any error of law by the council can be said to be excusable or inexcusable.
Yeah, well that goes back to the distinction that you made,
Yes.
that the judge didn't.
Well, it's implicitly there in the judgment. Sorry, that word implicit.
Well,
But
he sort of touches on it at paragraph 25, where he says, despite my ruling, the argument I heard on the selectivity criterion is not redundant, and shall have cause to refer to the context of the primary basis on which Mr. Robertson put the council that goes to TC had no real prospect of establishing a right to claim damages from the council.
It was there that I was looking for the next bit that explained why that was the case. Anyway,
Well,
there it is.
and that's why I placed emphasis on the word. I'd characterise that as implicit.
Yeah, okay. Okay. Anything else on ground two?
Only just to, and it's not really a ground 2 point, but it just occurred to me in the context of ground 2, meaning of selectivity. Because that's set out in the judgment as part of the definition of what is state aid at paragraph 11. And I just need to respond to what my learned friend said about selectivity. Paragraph 11 says on tab 9 of the core bundle, page 351, paragraph 11 at the top, the elements of state aid are recited there. Second, that the measure favours certain undertakings over others in a comparable legal and factual situation. That is, that a selective advantage is conferred. So that's what we mean by selectivity. Are you comparing like with like?
Yeah. Your case is they're not comparable.
Yes.
Yeah, get that.
And that's, therefore, there's no selective advantage. And I mention that because my learned friend started going off into the concept of a reference framework, which is something that we use when we're dealing with the assessment of tax measures under the state aid rules. And Mrs. Justice Falk talks about it in the Credit Suisse case, but it's just simply not relevant to the case that we're talking about, which is that it is at least arguable that there's no selective advantage.
And why is that relevant?
It's relevant because it goes to excusability.
Why though?
The judge takes the view that it's a permissible view that the council and the appellant are not in a comparable legal situation because the council has statutory obligations that the appellant doesn't. And therefore one can reasonably take the view that they are not in a comparable legal and factual situation. Therefore an advantage to the council is not a selective advantage contrary to the state aid rules.
That's only relevant if that was in fact the reason why they didn't notify, isn't it?
It's an objective assessment, so it's not a question of, and I should just pick your lordship up on your use of the phrase, their decision not to notify. Notifications can only be made by the United Kingdom.
Yeah.
It's in practice, it's through the business department when under this regime. So a council can only request the central authorities to make a reference, but this is an objective assessment as to whether or not. It's not a question of whether the council thinks it is or not. It is objectively, is it an excusable error for a council to conclude that it's not in a comparable situation to a commercial operator because it has statutory obligations?
That's only relevant if they did in fact conclude that at the material time when they decided not to ask the business department.
No, my lord, I wouldn't accept that.
Isn't that right?
I'd say it's an objective assessment, looking at the council without knowledge of what internally they decided or not. Objectively, could a council reasonably conclude that it was in a different legal situation to that of a commercial operator? And recall, of course, this particular councils generally had the benefit of Mr. Justice Warren's VAT judicial review ruling, pointing out that there is a difference in VAT treatment that arises from the different situation that councils are when discharging their statutory objectives. That's councils generally, of which Durham is just but one. That's
Number 5 in Nagasi is plainly not objective. Whether the infringer was acting intentionally or involuntarily.
yes,
Subjective.
Mrs. Justice Falk addresses that in the context of state aid in the Credit Suisse case. I was going to come to that later, but shall I just deal with that point now? Just take your lordship to that particular point. It's in... So it's in the judgment at, and the passage from Credit Suisse begins on page 369.
Yeah, paragraph 54.
Yeah. And I'll confess I was counsel for Credit Suisse, the last doomed attempt to get a Frankovich damages claim out of the state aid rules.
It's always good when people are relying on authority where they lost.
What goes around comes around.
Exactly.
But the point that your lordship raises is that she addresses at paragraph 90 over the page on page 370. Because this is a case where Credit Suisse argued that tax treatment in the bank payroll tax, which only applied to banks declaring bonuses in a 4.5-month period of the year, and therefore banks that didn't pay bonuses outside of that period didn't pay the tax. The argument was, well, they were receiving an aid because they weren't subject to the tax. Paragraph 90 from her judgment, as regards Nagasi Criterion 5, whilst the legislation was obviously intentional and resulted from deliberate policy choices, there was clearly no deliberate intent to infringe. And indeed, in that case, they'd taken advice from my opponent, in that case, George Perrott QC, about the possible state aid risk relating to other aspects of the rule. So that, not actually that aspect of it. Now, the point she's making there is that compliance with legislation, their decision to adopt legislation, yeah, that's intentional, but there was no evidence in that case to infringe the state aid rules. Well, if you look at the council here, it's just complying with the Environment Protection Act. It's doing what the legislation requires it to do. So it's a fortiori of the Treasury in the Credit Suisse case.
Yes, the argument put by Mr. Bowsher, he accepted there was no deliberate intention to break the law. That wasn't alleged. But using my own words to summarise what he submitted in effect that the council had been reckless. What would you say to that?
Well, the correspondence that's referred to in the pleadings is simply the council saying, we don't accept your argument that this is caught by the state aid rules. And what they're doing is no more than councils up and down the land appear to be doing. So, well, I can't take it really any further than saying that they're complying with the Environment Protection Act. They're exercising a choice they have as to what to deal with when faced with requests for disposal of trade waste. Stand back This is a case in which there's been a complaint to the European Commission since July 2018. If this was so blatant an infringement of the state aid rules that the council was disregarding warning noises from the Commission and acting recklessly, we'd have seen some sign of that by now. Instead, what one gets is letters from the Commission saying, we've looked at your complaint, taken it up with the UK authorities. Unless you tell us anything else, and they've told them a lot, we're not going to proceed with this. And that was the position before the judge, that they hadn't opened a formal investigation. And that was a year and a half after the complaint had first been made. Now, the Commission might be criticised by some for being bureaucratic or sclerotic, but I can tell you in state aid cases, if they were concerned, they would have opened an investigation by then. And since the judgment was handed down, we know that the Commission see that there's nothing in this. Now, against that backdrop, you can't realistically say that the Council is being acting recklessly. We know from correspondence that it's been taking advice, and I'm not waiving privilege in the advice, but it's been taking advice from a law firm that's got particular expertise in state aid matters. There's no hallmarks of recklessness there. So, my answer to my Lord Justice Arnold's characterisation of Mr. Bausch's submissions is frankly come off it. Look at the attitude that the European Commission has taken. And that, of course, is another Nagasi factor. Since I've mentioned Nagasi, can I move to ground one?
Yeah.
In our submission, the judge's reasoning can't seriously be disputed. He's correctly set out the test and the relevant case law on the second liability condition, sufficiently serious breach, paragraphs 43 to 54 of the judgment. If one I think it is worthwhile just quickly turning the pages there.
Starting at paragraph
43, which begins on page 364.
Yeah.
And he then he starts off by referring to a Scottish authority that says you've got to plead your case. That's a hangover from the point at which they hadn't. And he makes the point that the particulars of claim don't mention the state liability condition. That's paragraph 45. And Mr. Bausch says that it's sufficient, given the nature of the rule infringed, the consequences of the infringement, that's sufficient to get him over the sufficiently serious hurdle. Then takes the relevant passage from factor tame and over the page at paragraph 47, goes to Kerbler, where, and this is a passage which is frequently cited, Advocate General Leger reviews the authorities and says, my opinion, the decisive factor is whether the error of law at issue is excusable or inexcusable. And that's essentially the hallmark to the test. In another case I noted, Mrs. Justice Rose, as she then was, said really, is the error an egregious error? Anyway, you can see it's got to be a blatant error to attract liability. He then refers to Headley Lomas, which my learned friend...
I'd be closer to my comfort zone if we're talking about Headley Burn.
I wouldn't.
Headley Lomas, we looked at that.
Yes. And this is his high watermark that the mere, and the relevant passages on the next slide, paragraph 28 in Headley Lomas, the infringement of community law may be sufficient to establish the existence of a sufficiently serious breach. Maybe, not, is. And then cites Angus Growers in that house of the Court of Session, another case in which I was involved until it got to the Court of Session, acting for Angus Grose and a Frankovich damages claim against the Scottish ministers under the Common Agricultural Policy, nothing to do with state aid in that sense. And Lord Tyre makes the point where no discretion is conferred, and this is my learned friend's point, if you've got an obligation to notify, it's a hard-edged obligation. The mere infringement of a rule of community law may of itself constitute a sufficiently serious breach, but it will not necessarily do so. Next paragraph, it is not necessarily enough to give rise to state liability that an error of law has been made. More may be required and other factors must be considered. He then cites Nagassi, which we've been to, on page 369 in paragraph 53, the cited passage from Lord Justice Morris Kay, say the misunderstanding in that particular case, not a cynical or egregious misunderstanding. I think agreed. That's where Mrs. Justice Rose in recall picks up egregious. Then we get to Mrs. Justice Falk in Credit Suisse, and this passage is obiter because at this point she's already ruled against my client, that the differential tax treatment didn't constitute a selective advantage. So I've lost on that. She's dealing with the case in the alternative as to if there were a breach, would it have been sufficiently serious? And she concluded that it wasn't. She makes the point, paragraph 87, that a multifactorial assessment may be undertaken. The importance of this case... So it must be undertaken.
Must be undertaken.
Yeah, multifactorial assessment must be undertaken. And the importance about this case is the same breach of obligation that's an issue here. It's the obligation to notify to the European Commission. It's a state aid case. She refers to the Nagassi factors. She refers to Lord Justice Carnwath, as he then was, in Byrne and Motor Insurers. It requires, so the sufficiently serious test is not hard-edged. It requires a value judgment by the National Court, taking into account the relevant factors. She then says, clearly the state aid rules are important. There's also no discretion conferred on member states in relation to compliance with them. As regards the Nagassi criteria 2 to 4, it's worth remarking that the limited period for which a tax is in force has not previously been held to be state aid. It's a novel argument, which was presumably not apparent to anyone, bearing in mind that Credit Suisse's own claim was only made at the very end of the limitation, the 6-year limitation period. She then deals with points of detail. Then there's the point of paragraph 90 that we've already covered about what we mean by an intentional breach. And then responding to a point that my learned friend made earlier today, in that case, because the Treasury had waived privilege over the state aid advice it had received from Mr. Peretz, I submitted that Mr. Peretz's advice was that the state aid position was not risk-free. Mr. Peretz very properly advised that. And therefore the proper course was to notify the Commission. I disagree, says Mrs. Justice Falk. And she then goes on to say why. The point doesn't assist Credit Suisse because the risks being considered related to other aspects of the rules. It wasn't a particular issue that we were concerned about, the limited period of application. Secondly, as confirmed by officials' evidence, the government takes a risk-based approach in relation to state aid. Sorry?
Evidence.
And yes, this was after a trial.
Yeah, I understand.
Yeah. But the point is there that this isn't the case. If you stand back in the state aid world, it isn't the case that if there's the slightest risk of something being held to be notifiable state aid, that necessarily the government goes ahead and makes a notification. So that's not a factor in his favour. And then at paragraph 55, so that's the judge referring to the relevant case law on sufficiently serious breach. Now, my learned friend tries to minimise the importance of the Nagasi factors and the multifactorial assessment, and he does so by reference to the Hochtief case, which he mentioned but didn't take your lordships to. I will take your lordships to it because when he says that Nagasi is just one end of a spectrum and he relies upon Hochtief at the other end, that's incorrect. It's to be found in the Authorities Bundle, tab 10. And my learned friend relies upon the court, paragraph 43, which is at page 289.
Yeah.
And the passage is, in any event, an infringement of EU law is sufficiently serious if it was made in manifest breach of the relevant case law of the court.
And the word that I've circled is manifest, because everybody has their gloss, egregious, cynical, manifest, whatever. People seem incapable of looking at these things without having a gloss. But anyway, that's the gloss in this case. When I saw that, I thought it would be part of your submission to say, well, even that one sentence, you have to be careful with it, because when they talk about manifest breach, they're not simply saying there's a breach.
Yeah. And you've also got to be careful with it because, in fact, the passage refers to three cases, Köbler, Fuss and Tomasova. And in each of those three cases, that wording is followed by the words, in the matter. In other words, it's where a national court proceeds or national body proceeds in defiance of a ruling of the EU in the matter. And that was what was an issue in the Hochtief case. So, as well as circling manifest, I would invite the court to add in the matter after court, because in each of those three paragraphs cited, that's what the court says. And for some reason, it doesn't appear in this particular formulation, but there's nothing in the judgment to suggest that it's intending to cast the net wider than in Köbler, Fuss, Tomasova. And that is clear from, well, it's clear from the judgment, but I think it's particularly clear from a typically well-drafted opinion from Advocate General Bobek, who explains that this reference to the Court of Justice had followed long-running litigation in the Hungarian courts, where there had been a previous reference to Luxembourg. Luxembourg had ruled. The Hungarian court had come to a conclusion, and Hochtief then seeks to have that set aside on the basis that the Hungarian court has disregarded the ruling of the European Court in the previous reference. That is, well, it's clear from the head note in this report, in the weekly law reports. The passages in Advocate General Bobek are at 41. So on page 262, paragraph 41, as already alluded to in the introduction to this opinion, there were actually 3 rounds of litigation. He then summarises them. All 3 rounds, paragraph 42, are connected through a common thread: the alleged failure by the national courts through those different rounds to comply with a preliminary ruling issued by the court, that's the Court of Justice, in the course of the first round. And then at page 275, paragraphs 118 to 119, he sets out the case law where establishing the principle under EU law that damages may be available against a state where its courts commit a sufficiently serious breach of EU law. And then at pages 276, paragraph 132, the Kerbler standard adapts the condition of sufficiently serious breach to potential judicial misapplication of EU law. And then continuing on that paragraph, onto the next page, 277 at the bottom, in any event, an infringement of EU law is deemed sufficiently serious where it was made in manifest breach of the case law of the court in the matter, citing Kerbler and Tomaszova. So that's what Hodgetief is about. It's deliberate defiance of a Court of Justice ruling. And if you're going directly against what the Court of Justice has ruled in that case, then it's sufficiently serious as a breach. That's what Hodgetief is about. It's not the end of a spectrum, it's an application of Kerbler and Nagasi. Now, to state the obvious, there's no such ruling here in these proceedings. The case is still with the Commission. And when it comes to a final point before the Commission, then Malone and Friends, and they don't dispute this, can take their case to the European Court in Luxembourg. If the Commission refuse to act, then they can bring proceedings under Article 265 of the Treaty on the Functioning of the European Union for failure to act against the Commission, calling upon the Commission to act. The Commission is then under an obligation to make its position clear within 2 months of that, and then that act can be challenged by way of an effectively Euro judicial review under Article 263 TFEU, and then off you go to the General Court in Luxembourg. They haven't reached first base on that because matters are still before the Commission. We say the judge was correct to concentrate on factors 2 to 5, and really for the reasons that the judge gave. And his final conclusion at paragraphs 70 to 71, we submit is obviously correct. My final submission on Nagasi just really follows on from my learned friend taking you to what happened post-judgment. And this is Nagasi Factor 8, the position taken by a community institution. And just to draw to attention what Malone and Friends clients actually think the Commission think of their case. Because Malone and Friend took you to the correspondence, the letter from the European Commission, which coincidentally arrived just as judgment was being handed down, and very correctly drew that to the judge's attention at the consequentials hearing on cost submission to appeal.
He had that letter before him at the time he made his order?
No. He made his order on the 25th.
Right.
And then said, and I direct that there should be a hearing on costs and permission on the 27th.
Right, so he hadn't seen the letter. Had it arrived by the time of the judge's order?
I can't assist on that because it's my learned friend's letter.
When we looked at this at the time, we didn't think we'd received it. I mean, whether it had appeared on a fax or something, but we were not aware of it when the order was made. we became aware of it, or probably on about the day when we became aware of it on about the day that the order came through from the court. But it was certainly not something I certainly wasn't aware of it, and I knew that the judgment was being handed down on that day. I think it was probably later that day, on the 25th, as we were preparing for the 27th, when those instructing me said, and I tried to look at this in my email library last night, that was the best I could do, because it was probably sometime on the same day. I hesitate to say that it was not, I don't quite know what time the stamp was put on the document, that's all, so I'm hesitating.
Right, thank you. So, I mean, the position is as before the judge at the hearing, was as the judge recorded it. They've made a complaint to the Commission, and the Commission haven't picked it up, haven't opened formal proceedings. There's then rounds of correspondence with my learned friends' clients. They replied to the Commission on the 23rd of December 2020. My learned friend says that the Commission's letter somehow endorses or invalidates their case on selectivity because it doesn't refer to selectivity. Lords, one can't make that inference. One can only take the letter at face value for what it says, and they're minded to reject the complaint on the basis of lack of cross-subsidisation. That was the point that I think prompted my Lord Justice Arnold's observation, well, what's the council supposed to do to eliminate that cross-subsidisation? To which my learned friend said, put its prices up, increase its costs, and put its prices up to match those of his client, which will come as very welcome news to the business rate payers of County Durham, or indeed council taxpayers generally, County Durham, that rates are going up, or charges are going up.
No, it wouldn't be the council taxpayers who would suffer, it would be the customers for the trade waste.
Yeah, that's correct, I misspoke. Yes. So your charges are going up.
Council taxpayers would be quite pleased, perhaps.
Depends whether they're operating the businesses or not.
Yes.
The Commission replied to the letter of the 23rd of December on the 16th of June, and they say, essentially, the letter of the 23rd of December contains no new elements. And I should say this was a fully reasoned state aid complaint at the outset. So that was in the evidence before the judge. So the Commission have got a fully reasoned case from the appellant and have investigated with the UK authorities and have come to the conclusion that this isn't a case that merits opening a full investigation. They raise additional arguments in the letter of 16th of June saying lack of effect on EU trade. The appellant responds on the 15th of July 2021, and that's worth very quickly looking at. It's in the supplementary bundle at tab 8. It starts on page 158, and you'll see that it reiterates in the third paragraph. And so we don't know why you suggest that the information we submitted doesn't alter.
Sorry, which paragraph?
Sorry, that's the third paragraph on page 158. And then they pick up on the lack of effect on EU trade, point at the bottom of the page, turning over to 159. And this really reveals what this is really about. The first full paragraph, however, as was confirmed by the Trade Body for Commercial Waste Collectors, ESA, the issue of which our client complains is nationwide. due to the nature of local government structure. And they then set out their case there. And then they said this situation is not unique to the UK. They've provided a Belgian judgment saying, look, there's problems in Belgium as well. So what they're really taking issue with is lack of European intervention into regulation on a nationwide basis. The final paragraph on page 161 records that our client has been extremely disappointed by the apparent lack of understanding of the significant impact which the actions of Durham County Council and other local authorities across the UK is having on the trade waste market, and the fact that the Commission considers that this is not a blatant use of unlawful state aid. So they regard it as a fact that the Commission considers this isn't a blatant use of unlawful state aid, yet they're seeking to run a case before this court that is directly contrary to what they state there. That
But
takes...
I think Mr. Boucher's point is that these letters from the Commission suggest that the Commission has knocked out the claim on the evidence and not on a preliminary point of law, which is what the judge did.
Yeah.
I think that's...
The Commission's gone into it. It's gone into it in detail with the UK authorities and has not said this is a blatant use of blatant state aid. And that's the level that Malone Friend would have to get a sufficiently serious breach argument off the ground. And it's not even the Commission saying we've got concerns or it's arguable, it's the Commission saying we're not going to take action. Now in those situations where the council, Durham County Council, is being told you've committed an egregious, blatant, sufficiently serious breach of EU law, yet the body charged at European level with monitoring and enforcing the state aid rules has said, we don't think there are grounds for action. That's just... well, in our submission, that takes real brass neck to run that submission. I was going to say Johnsonian levels of brass neck. So, essentially, we agree with them that the Commission has taken the view that this isn't a blatant use of unlawful state aid. And for that reason, the judge was right to make the findings that this isn't a case of sufficiently serious breach that's fit to go to trial. The Lords, unless I can assist you further, those are our submissions.
Well, you haven't quite fully dealt with Mr. Boucher's submission about Mr. Justice Warren's judgment, because some reliance is placed on that by the judge in our case.
Yes.
And Mr. Boucher says that he was wrong to rely on Mr. Justice Warren's judgment because the context is different. What do you say to that?
Yeah. What Mr. Justice Warren said, and if I just turn up the relevant passage. Yeah. My submission is recorded at paragraph 64 of the judgment, so that's Core Bundle, tab 9, page 374. What we were advanced the judge below was that although this is a case about VAT treatment, if you look at the reasons why the different VAT treatment was afforded in that case, it comes down to a finding that the council was in a different legal position to that of commercial waste collectors. And that's because the council was under obligations under the Environmental Protection Act, which didn't apply to commercial operators. So that's the essential difference. Now, those findings as to what statutory obligations were on the council and what on councils and what that entailed demonstrated that councils operating under the Environmental Protection Act are in a different legal position to that of commercial operators. So at paragraph 65, Mr. Justice Warren noted the differences between the positions of local authorities and commercial operators. The council's commercial waste collection sits within a framework of environmental obligations and objectives. The council doesn't seek to make a profit and does not seek to increase waste collection. Rather, it encourages residents to reduce waste. That was evidence that was before Mr. Justice Warren from another council. Mr. Justice Warren noted that a local authority has wide social responsibilities, which a private sector does not, responsibilities which include statutory duties. Its purposes in providing a particular service may be to fulfil those responsibilities. And that is why he then concludes over the page on 376 that for VAT purposes, the Environmental Protection Act regime is at least capable of being a special legal regime for VAT purposes. And that's what makes the council's provision of services exempt from VAT, whereas the commercial operators are not operating under a special legal regime and therefore are required to charge VAT. So it's a conclusion under VAT legislation, but the reasons for reaching that conclusion under VAT legislation are equally applicable here. It's a different legal regime, and therefore you're not comparing like with like. Therefore it's not a selective advantage.
It's clear from the judge's approach that he placed significant weight on the VAT decision of Mr. Justice Warren. What is slightly less clear to me is if we just look at section 45 and the waste collection point, your clients are an undertaking for those purposes, so is Mr. Bausch's. So why is that a different legal regime?
Because we're an undertaking that is operating under a special legal regime, and they're an undertaking that isn't operating under a special legal regime.
Yeah, but when it comes to waste, sorry, commercial waste, trade waste, you're in the same position because you're not obliged to do it.
But if we exercise our discretion to do it, then when we're doing it, we are subject to all of the requirements of the Environmental Protection Act, just in the same way as our household waste.
But that's tantamount to saying you're not obliged to do it, but if we do it, we're in a better position than our competitors.
Well, if we do it to achieve objectives under the Environmental Protection Act, I mean, after all, what purpose would be served having our fleet of 86 refuse collection vehicles drive past commercial premises which would like their trade waste to be collected? And why would you have a second round of lorries?
Well, you could say that in relation to the privatisation of most of the industries of this country since 1979. So that is not an answer.
Well,
I'm afraid.
Yeah, it's an observation that an efficient use of the vehicles can also include picking up trade waste if so requested.
Of course, all of that I completely understand. But the key sentence, the one I put to Mr. Bauscher, the key sentence is the one in paragraph 67, where he accepts effectively your submission, although he doesn't decide it. He says it's at least strongly arguable, that it doesn't provide its commercial waste collection services on a commercial basis, but under a specific regime for environmental protection. But he's taken that from Mr. Justice Warren's case with evidence that he didn't have. And at the moment, I don't see, just looking at the question of commercial waste collection, why there is a difference under Section 45. I mean, is there anything in Section 45 that you rely on to say, well, that therefore they're not comparable?
No, what I rely upon is the judgment of Mr. Justice Warren, establishing that when the council does provide commercial waste collection services, it is operating under a special legal regime. And that is a point which is at least arguable. The judge said at least strongly arguable. And therefore, in the multifactorial analysis, is a reason for concluding that the council is not committing an egregious breach of the EU state aid rules. It is at least strongly arguable that it's operating under a special legal regime, which means that it is not in a comparable legal situation to that of the appellant, and therefore is not being conferred a selective advantage. And one only has to establish arguability to show that that's not a blatant, egregious, sufficiently serious breach, an inexcusable error. It's certainly debatable.
So you say you only have to establish arguability. What do you mean?
Well, my learned friend has to establish that the council has committed an egregious breach.
He has to show that it's
Yes.
arguable,
He's got to show that it's sufficiently serious.
but that it's arguably sufficiently serious. The burden's on you. You're trying to knock the claim out.
And I say that it is arguably not selective, because they are, at least arguably, in different legal positions. And if that's the case, it can be one can reasonably take the view that there's no selective advantage. And if that's the case, then you're nowhere near the threshold and wouldn't be at trial of establishing a sufficiently serious breach. After all, if there were, the Commission would have jumped in on this case. They've had enough submissions from the learned friends over the last 2.5 years. And the Commissioner are intensely relaxed about this.
Well, I don't think we'll be deciding this case on the basis of what the Commission did or didn't do. So you say, effectively, you don't rely on Section 45, you rely on what Mr. Justice Warren said in the VAT case. So you say it's at any rate arguable that they are not comparable, but even if that's wrong, you say it's not I'm not going to use the glosses, it's not a sufficiently serious breach. Yeah, I understand that.
Only one thing. Section 45, subsection 4 of the 1990 Act. Deciding whether we're in a comparable position, one might look to see how they decide what to charge their customers. And the customer of the council is liable to pay a reasonable charge, which is not the same thing as a market rate necessarily, or it might be. Do we know anything about how that provision is applied by the council, or indeed in...
I think that the most we can say is the Commission have taken this up with the UK authorities and came to the conclusions that they did in their letter of the 24th of November, which is they considered was a 6.5% profit margin to be reasonable.
Yes. I mean, they don't have to charge a profit margin at all, but if they do, they might be said to be acting commercially, I suppose.
Well, I think my learned friend rather would prefer them to have an increased profit margin.
Yes, yes.
It's just the slight oddity of this case. One of the many slight oddities of this case.
The starting point, as far as subsection 4 is concerned, is that that is what empowers the council
Yeah.
to levy the charge.
Yes.
And it's a constrained power because the council only has power to levy a charge which is reasonable.
Yes.
But although it gives the council power subject to that constraint, it doesn't require the council to charge at all.
In which case my learned friend would be even madder. If we were doing it free of charge.
I just want to be sure I've understood the framework under section 45 correctly. Is what I've stated correct?
On the face of it, shall be liable to pay a reasonable charge doesn't require a charge to be imposed. So, I don't have any instructions on how this, whether advice has been taken on the interpretation of this. And maybe I might be wading into deeper waters if I start expressing a view off the top of my head. But your lordship's reading on the face of the legislation.
Well, because the counter argument is, it goes on to say it should be the duty of the authority to recover the charge. And it might be suggested that indicates that it's not appropriate, it's not within the council's power to levy no charge at all. It could be a modest charge.
Unless it considers it inappropriate to do so.
Yeah, at least they've got to think about
Yeah.
whether the cost of the administrative costs of levying and collecting are such that it's not worth doing.
Yeah. And my learned friend's gloss on that must be a reasonable and lawful charge, by which he means a reasonable and higher charge, I think.
But certainly there's nothing there that requires a market rate to be set.
Yeah. And I think that's a point made by Mr. Justice Warren.
Yeah. All right. Thank you.
All right. Thank you. No, thank you very much, Mr. Roberts. If you finished,
I have finished.
you have finished. Thank you very much. Yes, Mr. Bash. Anything in reply?
A couple of points, really, just to pick up on the way the selectivity case appeared below, and a few points to follow on to that, leading into that last point, the last series of exchanges. I hope not to be too long on this. Firstly, in terms of the case on selectivity, it is relevant to note that there was in the pleadings a case on selectivity. It appears in the pleadings, in our pleading, in the core bundle particulars of claim, page 399. I took you to this before, but didn't draw out the points clearly. That we positively identified in 28C our case that the selectivity limb was fulfilled for this to be a state aid. So we, as it were, put selectivity in issue. And the only pleaded response to that was the paragraph 30, which we've seen before, which was just a bare denial. That's at page 418. Now, I don't think it's necessary to get into debate about how one should or should not plead the matter, but it is significant that there is no positive case pleaded in the defence saying it's not selective because we're in a special position. There are a number of positive cases which frankly, we would say should probably have been pleaded. There's no point in getting into that.
Can I ask you this question? Would you accept that you couldn't have been taken by surprise by the reliance on Mr. Justice Warren's decision, given it was between the same parties?
I would accept that, yes. Right. But we would also say that it's, I'll come on to that decision in a moment. It is also significant, as I've made the point already, that in no part of the Commission analysis we've seen relies upon that selectivity arguments which have been deployed. On the contrary, the Commission's arguments look at a positive calculation about cross-subsidisation, which clearly refers to material which certainly was not pleaded or referred to in the pleading, and certainly in our submission a natural reading of the defence would lead one to suppose that such material didn't exist, certainly at the time the pleading was pleaded. And
You
so-
made that
I've
point
made that
this
point
morning.
already. I shouldn't. Sorry. So, what is when one turns to the relevant passages in the Warren judgment, going back to paragraph starting in 65. As you know, it's our position that the statutory obligation, and it is important, statutory obligation is the arrangement, and that point I know your lordships have. That's what the obligations bite on. When one looks at the narrative in that judgment, you can see that Mr. Justice Warren takes the view. Can I just jump to the passage? It's after the first quotation in paragraph 65, so it's Warren J. noted.
Mm-hmm.
You have that. Warren J. noted the differences between the positions of local authorities and commercial operators. He referred to evidence which was not the subject of challenge from North Lincolnshire, so not this council, that the council's commercial waste collection therefore sits within a framework of obligations and so forth. The council does not seek to make a profit and does not seek to increase waste collections. Well, that's would seem not to be applicable in this case, because as we've seen, we don't know what lies behind it. We've seen from the Commission letter that there does seem to be a positive position that this council does seek to make a profit. Now, it's not directly our concern what level of profit it makes. Our concern is the charge that it levies.
You want it to make a greater profit.
Well, so up to the council what profit it makes. That's about good management of resources and so on and so forth. The question is the charge it levies lawful, or is it, to go back on to go to the Commission's analysis, have they made a proportionate allocation of fixed cost? And you have that point. But when you then turn over the page and look at what is being said about the facts of that in that case, which is about the North Lincolnshire situation, you can see that what Mr. Justice Warren comes on to and deals with is from paragraph 10. We need to read 103. I probably need to look at. It's really the whole 103, 104, 105. He's dealing specifically with 45(1)(b) as a special legal regime. Well, we say. He says, I have no doubt that this section is capable of being a special legal regime. This is demonstrated by consideration of the local authority which provides commercial waste collection only if requested to arrange and so on and so forth, which results only in cost recovery and no surplus. Well, that is in that case. That's not this case. Indeed, we don't deny that a local authority that is actually arranging a collection and then levying a charge may be acting as a public authority. But, and this is the next bit, so 104, since it cannot be said that section 45(1)(b) is not ever capable of constituting a special legal regime, it must follow that on the TDC's case, whether any particular authority is acting will depend on the facts relevant to that local authority. So we're back to the factual analysis to what happens here. And there's clearly a distinction, just on the face of the wording of Mr. Justice Warren's judgment and the evidence, the material, it's not evidence, the material that you have from the Commission correspondence, there's clearly a distinction. And if Durham, sorry, I should carry on 105, it is therefore impossible to answer the preliminary issue, and that's the point. This was a case about a preliminary issue, about the application of the VAT derogation, and clearly Mr. Justice Warren is looking at that on the basis, well, the question was framed, does the derogation apply or not? And North Lincolnshire, as a case, established one particular answer. But what in fact, in the prior section, Mr. Justice Warren is saying is, in any particular case, one has to look at the facts of the market and the facts of the way this council operates. And the way this council operates is as a profit-making undertaking competing against my clients. We don't object to them making profit. What we do object is to what we say is an unlawful approach to the allocation of fixed cost. because that enables them to fix a charge which distorts competition and is therefore unlawful. Now, my Lord Justice Arnold put to my friend that my submissions amount to my saying that they were reckless. It may be that I reached that high. I say I don't need to reach as high as reckless in the sort of the technical criminal law sense. What we need to say is they were deliberate. They have deliberately decided to set up a commercial waste business. They've deliberately decided to set that up in a way that is profit-making. They know that they are competing against my clients and others. All that is deliberate. They take a view as to whether it's lawful or not. Now, it may be that at that stage, it's right to say that our case is that they are reckless as to whether it is lawful or not. But they take a view, but on the criterion, on the Nagasi criterion, sorry, I've got a moment, number 3. That is sufficient to make I don't need to go to show deliberateness or deliberation in the sort of misfeasance sense. And I don't seek to do that. I didn't have the material to do that. All I do need to do is show that their action was deliberate. They must have known, and they certainly later on in the process knew there was a legal constraint in play, and they've taken a view as to how to deal with the matter. We do not have any pleaded case on selectivity explaining why they say this isn't selective. They haven't, for example, at this stage, perhaps not surprisingly, taken the course that was taken in Credit Suisse and waived privilege in any part of the advice. We don't know anything about those internal ruminations. But at this stage, we must have a realistic prospect of, so particularly when one sees the inconsistencies which I've already highlighted between the analysis that is put before the judge and the analysis that is run by the commission. Maybe those can be explained, maybe they can't. But at the very least, at this stage, we submit a realistic prospect of showing that the Nagasi criteria are fulfilled, and that whether or not, and that it is not enough to say, well, selectivity was difficult for us, when clearly they have deliberately set up a profit-making undertaking to compete against us, and we say distort competition, distort the competitive conditions between us. And also, unless I can assist any further, I think that really is that's our position.
Let's make a note of the last one. Thank you very much.
Sorry.
Yeah, go on.
The other thing I was going to say, you asked us to provide copies of the extracts from Bacon. We've clearly had communications problems with our clerks from. Can I send them over tonight? Can I bring
Yeah, no, that's fine.
Attempts to bring them down this afternoon have produced.
I mean, I've read the extracts. Obviously, we've all read the extracts that are in the judgment. I would just like to see them in their context.
Yes.
from the book. All right, thank you very much, Richard. Anything else? Right, well, thank you very much, Mr. Boucher. Thank you very much, Mr. Robertson. Thank you very much to everybody sitting behind you. There are a number of issues. You'll be unsurprised, therefore, to learn that we'll reserve our judgments. We will endeavour to do those as quickly as possible. When we have done them, we will send them to you as drafts. As you know, that's your opportunity to correct our grammar and our spelling and other typographical errors, of which there are usually quite a few. It's not an opportunity to re-argue the points. Once you have kindly dealt with that, we will then produce the final version, and those will be handed down. And at the moment, as you know, they're all being handed down electronically. But even if we were back to the old regime, there would be no need for anybody to attend. Thank you both very much.